Good morning, everyone, and welcome to Business Immigration Gateway webinar series. I'm Sajjad. I'm Business Development Manager at GenesisLink, and I'm your host today. And I think we need less than a minute for others to join. But before starting the webinar, I need to have a disclaimer. So just give me a second. So here you can see the disclaimer exactly. Have it in mind, always you can ask your question in the chat box, and we're going to answer all the questions in our Q&A session at the end of this webinar. So the first and most important notice in the beginning is our disclaimer. This is an educational session, not a legal advice for your specific case, and attending doesn't make Eiman your lawyer. He's speaking in a personal capacity, and his views are his own, not his firm. For advice on your own files, please talk to your licensed professional, and we'll email the recording to everyone who registered and follow up on any questions we don't get to live. So I think as you're joining. Perfect. Just before starting, I'm gonna make sure that all things are fine here. Perfect. Everyone can okay. And also you can see little bit of intro about GenesisLink here. We've worked on business case immigrations since 2020. We've helped a lot of business professionals and RCICs for their clients and applications. And we are helping them with different business services from financial planning, business plan writing, and all the activities that a business needs to establish in Canadian market. And since beginning till now, we've worked on more than 300 business immigrants. And also we worked with more than 20 immigration partners. And till today, we didn't face any refusal and rejections on our files. And in terms of our today guest, we have Eiman Sadegh today, who is founder of Canadian Future Law Firm. And he's been working on immigration and law firms since 2009. And he is a member of Quebec and New York bars. And his special expertise and our area of practice is involved with federal court judicial reviews and mandamus applications, and also business immigration applications, which helps a lot for added value to this special webinar. And welcome, Eiman. Thank you for joining us. You can have an intro here, and then we can start the webinar.
Thank you, Sajjad, for inviting me. Thank you, GenesisLink. It's truly a pleasure for me to be here today, and thank you for the introduction. So whenever you'd like to start, we can. I just a little addition to my profile. So when I first began my career, I was working in the Quebec Investor Program. So in 2009, after that. So I dealt a lot with investors looking to come to Quebec. After that, I spent a few years working on owner-operator, LMIA exempt work permits. Following that, I got involved with the startup visa program, as well as federal court judicial reviews and mandamus cases, like Sajjad said. So the goal of today is for me to try to provide all the practical knowledge that I got over my years of practice. I've assisted a lot of different families from different realities to submit applications under various business immigration programs. So if there's, by all means, I think the point of this seminar to provide as much practical information as possible. So whenever there is a question, I invite you to write it down so that we can go over it, because the practical aspects of these programs are the most important. And that's what I'll get into as soon as we begin the conversation.
Perfect. Thank you. Thanks a lot. I think I got a message from Manish. am I echoing? I mean, is my voice coming through? I mean, do you have any problem with my voice or?
I hear your voice pretty well, yes.
Okay, okay, so perfect. So for this session, for our today's session, we are focusing on protecting business immigration clients under IRCC new scrutiny. And we have four different topics for today, which start from what's changed and the new refusal landscape. And then we're going to focus on building refusal-resistant files, how we can help our clients and applications to, avoid any rejection and refusals. And also, once we face any refusal or PFOs, what are the actions that clients can take? And then we're going to focus on best moves during procedures and especially during the backlog. So since beginning of 2026, we have seen a lot of changes in business immigration. In the beginning of 2026, I've seen actually IRCC stopped startup visa applications and procedure on these kind of applications, which was a huge shock for the business immigration. Also, we've seen a lot of changes on PMP business programs like BC that uh, we have new documentation, new regulations for BCPMP business streams, and also in terms of C11 and C10. The way that IRCC is validating applications is kind of different from before. They are checking the temporary intention of applications, and also on the other aspects of business immigration, we're still waiting for OIMP and Ontario programs to be released for entrepreneurs. So these are a lot of changes that we've seen since beginning of 2026. So that's why we got a lot of requests for this specific webinar. And in terms of the first topic, before starting topic, I'm going to run a poll to see how involved our audience are with our webinar. So let me see how can I run this poll. Just a second here. Okay, so the first poll before starting the first topic is how central is business immigration to your current practice? So we want to get a better sense of our audience. So these are four specific options here. It's my primary focus around mostly business files. The second option is a regular part of the mix, a few business files at any given times, or you're working as an occasional period. So I take business files when the right client shows up. And at the end, we have new to business. So I can see a lot of answers here. Let me show the result. Okay. So around 33% are regular part of the mix. So, and 17% of our audience are focusing, working on business immigration. And we have some audience that are new to business. So now I have a better understanding of our audience. You can see the result here. Perfect, perfect. So let's begin the first part of our webinar. So, Eiman, I know there are a lot of debate about the refusals that we have seen in business implications. Let's begin with the first question. What's actually driving the rise in business immigration refusals right now? Which of the newer grounds, temporary intention, financial reserves, document verification, what are the things that RCICs needs to take care of when it comes to business immigration applications?
Yeah, I think that's a very good way to start the conversation. Since I started my career in 2009, I've seen a categoric, one-directional pull of IRCC in terms of business immigration. The criterias have become more restrictive. The number of applications that are being accepted has dropped, as you mentioned. I will never forget when I first started doing judicial reviews, I think it was in around 2021. I remember what, for example, you take a C11 file, what passed then, what were the requirements, and what the bar is at now. It's a completely different level. The one thing that is important to realize is that there's really a distinction that's being drawn between eligibility under a program and sufficiency or credibility, for example. And what I see very often and what I've seen is the continuing trend where credibility becomes a lot more important than pure eligibility. So this is something that we'll look at as we discuss different type of programs and applications. But um, I always like to say back in the days, 2019, 2020, getting a C11 application accepted was much different than today. The just having a registered business with a business plan, maybe a landing page, a little office, registered office somewhere might have been enough to get you through there. But now it's no longer the case. So what has really changed is, first of all, the amount of documentation and the amount of proof to show that not only is the person eligible, but it's an actual credible file that's going forward. So that's, I would say, is the biggest hurdle or the biggest mindset to try to get behind. It's not a question of do I meet the boxes? Do I have for example, a corporation which I own more than 51%? Yes, I check that box, but more than that, what is this corporation doing? How can I show that it's actually began activities and that it's an actual genuine endeavor and not a business plan that I've developed just to get a work permit and to come to Canada. So that's, I would say, the biggest change that I've seen develop over the last 10 to 12 years. Um, in terms of the other aspects to keep in mind, I think temporary nature is always one thing that trips practitioners up in these type of files. It's hard, to demonstrate the dual intent potentially in these cases. You're trying to make a credible case where someone is going to leave all of their activities back home, come to Canada, for example, operate a business, start a business for a year or two, and if things don't work out, well, it's a dual intent. So if things don't work out, he will go back to his home country. And that's a very difficult thing to prove, but you must absolutely show that for example, in the case of a C11, if the person is coming in, or an intra-company transfer, for example, if the person is coming in to set up the corporation, you need to discuss what is the exit plan. The person can have dual intent, that's not a problem, but should dual intent not materialize, what is the exit plan of this person who has come in to set up the business and lo and behold, he can't obtain permanent residency? What is the exit plan? How is the corporation going to survive? That's the one thing to show. Number two, ties to your home country, which becomes difficult because you kind of have to uproot yourself to come to Canada and to start the business. But you should show that you have ideally an active business abroad. How is it remaining active with you in Canada? That's a question to be asked. That you have assets abroad, that you don't necessarily come to Canada with your entire immediate family. So these are all things that demonstrate to the officer that the intent is temporary. My business is still active at home. I might have brought it down a bit, but I'm not abandoning it. My assets are still there. Maybe not all of my dependent spouse and children are coming with me, perhaps. These are all things that you have to really consider as a practitioner because clients want that easy solution. I want to come to Canada fast with my entire family. So what is the best approach? I want my entire family to come. So you have to really do a good job of letting your clients know, managing their expectations around all of these different aspects. When it comes to financial reserves, I think that's something that's always been one of the most important factors when it comes to IRCC processing. And I think the number one thing to keep in mind is that, if your client owes has an asset pool of, I'll make it easy, $10, and he's reaching into his pocket and he's going to spend that $10 to invest in a new business in Canada, then you should really be careful. Anyone who is in the field of starting a new business or has launched themselves in business, I know we all have, and we see what happens in immigration. There's ups and downs. So it's the same thing in any industry. If you don't have any kind of leeway or runway in terms of assets, and you're investing 90% of your available pool of assets into this endeavor, that's a big red flag, because what if you don't get clients in month 1, 2, 3, 4, 5? What if there's an extra expense that you have to cover? These are all things that that the officer will look and say that the individual is covered up to here in cost. If one thing doesn't go according to the business plan, and by the way, business plans rarely go the right way. There's always, anybody that's ever executed a business plan knows that you start with there's so many things that go unexpected. So that will happen, and so you have to have the finances to be able to cover that. I would say these are this is how I would describe the new refusal landscape, and what are the items that RCICs should be the most alert to when it comes to their files.
Yeah, perfect. Yeah, I've seen that especially for C11 owner operators permit, they have renamed the program to temporary resident intent, which is kind of reflect the things that you mentioned. The applicant needs to show that they have temporary intention to run their business, although they can have the dual intention, but showing that you have this temporary residency and intention for this is really important. And I've seen a lot of backlog as well. There are a lot of applicants that are waiting in the backlog. And given these changes, how they can actually make a application or file that can survive through this environment? Other than the financial aspects, what are things that they can add to their application to survive in this situation?
So you mean when the processing times become very long because of the
Exactly.
backlog? Yeah,
Exactly.
I think that's where clients are put in the most difficult of circumstances, because you're in a position where you have to show that your intention is genuine. You want to come and carry out your business plan, or you've already started and you want to come and complete the execution of your business plan. So you have to show all of those. But then when you have to show that across a very long period of time, it becomes very difficult. There is no, Sajjad, there's no secret recipe answer to say, hey, what should this client do while he's waiting for his processing time? It really becomes a case-by-case analysis, where we have to see what was promised in the business plan and what was promised to the officer on day one. If it has not been achieved, and this is due to processing delays, it needs to be very clearly explained that, for example, if you take let's take a startup visa applicant, for example, that they have a solid plan and they were supposed to, one phase of their development was to go and secure funding, for example. And they had envisioned that they were going to get their PR after 2-3 years, and that they're going to be able to get their funding and raise money because they have PR. Lo and behold, the program changed, the delays changed, and as a result, they cannot get PR yet. And if they don't have PR, investors won't touch them with a 10-foot pole, because they have zero standing here in Canada. So if that is hindering their development, they need to find a way to explain this to the immigration officer and find a way to pivot, because you can't just sit there idly by, turning your thumbs. Although in practicality, it's almost very difficult to actually do anything until you actually get your permanent residency. We have to look at everything on a case-by-case basis and say, hey, in this case, for this client, what can he do or she do to improve her chances of getting accepted now that they're in this timeline that we don't always even know when the timeline is coming to an end. So it's a question of showing that your business is still valid, that you're still actively looking to pursue it, and that it's still a business that's, of course, attractive for Canada. And that's where I think one of the biggest problems comes in when there's processing delays that border ridiculousness. When we're talking about, for example, the startup visa, is that after there's a decay when it comes to your business idea and your business innovation. And that I think is the hardest piece to try to grapple with, because your business idea is good today, it's developed for today. If you have to wait 1 or 2 years without doing anything, then you potentially don't. Your business plan has to be revamped. You have to pivot. You have to keep doing market research to show that, how do I still remain competitive? How do I still remain innovative? And what happened to that initial business plan that I had? What am I doing with it now? So it has to be a very pragmatic, case-specific updates that are being provided on your file, so that when the processing gets to your file, you're still eligible and that you still meet all the criteria that the officer is looking for.
Perfect. Thank you. So, as you mentioned, they need to show that they are active during the backlog. But how they can show it? I mean, do we have any evidence or any documents or anything that shows they are actively manage the business and they still have their intention to come to Canada to establish that business? Do we have any evidence or specific documents that IRCC needs to see in the backlog?
Yeah, I think, look, there's no magical ingredient list. I wish there was. That's how it was before, but now it's you have to proceed with the mindset of, if this was not an immigration case, what would I be doing for this business? You very, very pragmatic and very practical. I'll give you an example for a C11 case that I was working on recently. And we actually managed to get it through. And I'll give you a couple of examples of the things that we did. So yes, we registered the corporation. Yes, we built the business plan. Yes, we had a virtual office for them initially until they actually got their work permits. The processing of the work permits took, I believe, 1.5 years, okay, which was kind of ridiculous in and of itself because of the processing time, but that's a mandamus problem. And what I think actually got this case through is the fact that this person was a Turkish national. They were coming to Canada to establish a business that was involved in airplane parts, and they were going to link Canadian manufacturers and Canadian distributors to corporations in Turkey. Now, that is the general idea of it. But what this person did, he was lucky enough to be able to come to Canada, have a visit to Canada, open a corporate bank account, put certain funds into that corporate bank account and say, hey, this is the money that I'm going to use for my business. He was able to show that he had met with Canadian suppliers, Canadian distributors. He had shown emails exchanges that showed that he had potential clients in his home market. So, it became a very practical case of, if I was actually doing this business, what would I be doing? Forget about the visa for a second.
Right.
What would I be doing if I was actually doing this business? So I think that's where you can start getting some answers to the question that you asked.
Perfect. Thank you. Yeah, the mindset is really practical. And we have a lot of clients that's we're helping them to have this mindset, because you need to, for running the business, you need to, the first thing you need to establish that business, manage that business. And yeah, immigration is kind of support you for this. I got a question in the chat box. I think it's better to ask this question right now. So this question is, with the stoppage of the work permits for startup visa applicants, how does IRCC expect them to start up the business? Having said that, is there any other way for them to get into the country? Yeah, I think they've seen RCCs are trying to find some other ways for their clients to help them to come to Canada, establish that business. I mean, do you have any input for this?
I mean, look, so I think this was Mr. Sanjay Grover. Hi, Sanjay. Yeah, look, the question that you're asking me, I think, is one where we're all left scratching our heads and banging our heads against the wall. So how can you expect a business to have any kind of activities when the shareholders don't even have a work permit? You know, the clients with a tourist visa, there is very, very little things that you should legally do. Now, there might be other things that you could do, but legally speaking, there's only a few things that you could do. You can't even come to Canada for market research if you only have a tourist visa and you're a shareholder of that corporation. I've been on calls with CBSA officers looking to because I've had the same situation as you. I've applied for business visas, like tourist visas for them, but in the business category to come, and the amount of scrutiny they receive at the border is just absolutely ridiculous. And border officers don't necessarily know that you can't apply for a work permit under the SUV program anymore. So just becomes a real soup of disasters. What I would suggest is what are the avenues that are possible? Of course, the TRV for these people, but what is it actually worth for the client to get the TRV? You could try a C11 work permit. You definitely could try it, even though the person is a startup visa applicant. If you're able to show that their entry with a work permit will unblock that significant benefit, you know, that's the thing. It's like their entry is the key that unlocks the significant benefit for the Canadian economy. So you could look at those type of these LMIA exempt work permits. So if it's an intra-company transfer, you can go with the other exemption code, which was C12, but now it's changed. A C10, you could try to. The it's you know C10, C11, they're very similar in terms of what they want. You since you already have a business plan, you have a corporation that's set up. I would tend to go with these LMIA exempt work permits, but you're gonna have to show a lot more than just a letter of support and a registered corporation and a business plan. That's the thing. So though that's what I would suggest to you, and good luck because it's going to be a challenge.
You're right. Yeah, we have seen a lot of refusals on C11 as well. I mean, the rate of refusal is a bit higher than before.
Yeah, it's high enough. And I've also seen, I've done a lot of cases at the federal court when it comes to C10, C11, intra-company transfers. I've seen them a lot, and the criterias of the court are also changing and revolving, but they're still very viable programs if you know how to
You're right.
correctly enter the information.
Exactly. Okay, let's move on to the next part of our webinar, which is about the time that we get refusal for our clients. Before starting that part, I'm going to run a poll to see, I mean, if it's happened to our audience or not. So let's run this poll together. Just, um, okay. Okay, so this poll. In the past 12 months, have you had a business immigration file refused? Yes, one or more. No, but I've seen more PFOs. No, I've handled no business files in the past 12 months. Iman, what do you have for this? I mean, in the past 12 months, I mean, the rate of refusals on business immigration, I personally think is a bit higher than before because of the scrutiny level of IRCC. But what do you think? I mean, are we getting higher?
Absolutely. I think the last 12 months have gotten, I would say, going back the last 48, 50 months, the rates have gotten from a lot higher when it comes to refusal. It's been a clear one direction. You know, I would say ever since the Quebec Immigrant Investor Program closed, the rates started to hike up because that's when a lot of practitioners were looking for a solution. So a lot of them went to the startup visa program, a lot of them went to these LMIA exempt work permits. And unfortunately, both categories, IRCC came down on a hammer with a hammer on them. So I anybody that tells you that they're not getting refusals these days, um, either they're Superman or there's something going on with what they're saying.
You're right. Okay, let's see the result. So about 1/3 of our audience got refusal just in last past 12 months, which shows, yeah, we got a lot of refusal on business immigrations. Although we have some others that answered no, or they didn't have the business immigration files. But yeah, 1/3 of our audience got refused for their applications within the last 12 months. So let's start this part with this question. I mean, once the client got refused, how do immigration professional needs to decide? I mean, do they need to reapply or reconsider or going to the immigration appeal division or federal court? I mean, how they need to deal with the refusals or PFOs in this business immigration path?
Okay. I think yeah, obviously the first part is to manage your client's emotions. They're probably gonna want to blame you. They're upset. They want to they want to vent at someone, and venting at you is a lot easier than venting at IRCC, unfortunately. So I think what you have to do is, of course, immediately inform the client, and then you have to look at the refusal notes to see what exactly happened. What was the exact documents that were submitted? What was the decision-making rationale of the officer? I'm not just talking about the refusal notes. I'm talking about either the officer's discretionary notes for temporary residency, GCMS notes for their PR applications. So basically, what explains the decision logic-making process of the officer. And then you compare that logic making to what the facts were, and you see if it makes sense that this is what happened. Now, when there is a refusal, you have three avenues of action that you could take for your client. The first one is you could request a reconsideration. Now, reconsideration, we're all familiar with it. The when it works, it's awesome. You're the champion. Usually the client get accepted. A lot of times though, it's a shot in the dark. You send your request for reconsideration, you don't get an answer, it vanishes in thin air, or you get an answer saying that we've looked at it again and we don't think it merits to be reconsidered, even though sometimes it's obvious that the refusal says the sky is red and they don't want to reconsider it, even though the sky has never been red. That's unfortunate. So it's good when it works, but it's discretionary and you never know if you're not going to get an answer. So that's a reconsideration. The second one is, of course, you could resubmit the case, but resubmit and do what? You need to understand what was the issue. Was there an issue, firstly, or was it the officer who was on another planet? But if the officer was right, then what are you doing to fix the situation now? And the third option is to go to federal court if there's no reconsideration that's made on the file, if there's a obvious error or an error that's less obvious that a lawyer might have to look around. And so then you could go to court. The question that I ask is, I've been doing immigration for a long time, and I would say up until 3-4 years ago, I would not go this route, but I've kind of changed my own perspective because the goal is to try to get the client here as quickly as possible. So let's say if you're dealing with a temporary residency application and a PR application, it's a whole different world though. Look, let's say you got refused a C11 work permit. Okay. Now, the client has a few choices. They can turn around tomorrow, resubmit a new C11 work permit application. It's not the same thing as example as start a visa PR program that if you're refused, well, you can't really turn around and resubmit a new application. But for temporary residency applications, this is the way I say to proceed. If there's a reason to ask for reconsideration, ask for it right away, but don't sit around to get your answer. If there's an error, file a judicial review right away and resubmit the application. And in your resubmission, you mentioned that, hey, the file was previously refused. By the way, we went to court because we believe the previous refusal was didn't make any sense. So kindly pay attention to this new application. So I always, for temporary residencies, I say go all three routes: reconsideration, resubmission, judicial review. See which one gets you the result first. And if whatever gets you the result first, you can withdraw the other application and you're not going to, the question, the result is you want to get your client in quickly. Now, I say resubmit and go to the court at the same time. The reason I say that is because just resubmitting 2, 3 times, I mean, all of you have probably tried it once or twice. You're just going to keep getting multiple refusals, multiple refusals. The issue with the federal court is that the process is long. So although you're going to go in front of a judge, and if you win, if the judge gives you reason, then it goes back to the embassy. The process can be very long. So I say have two parallel tracks going at the same time: resubmission and judicial review. Whichever gives you your first result, then you withdraw the other application. So that's what I think should be the strategy. Now, when it comes to PR refusals, that's a little different. Of course, resubmission is not usually no longer possible, especially in these business-related cases. Eligibility, different documents, program might no longer be open. So in those cases, I think reconsideration and judicial review are your realistic options. How valuable will those options be? Of course, it'll depend on the specifics of your case and what was the decision-making process of the officer. So that's what I would say, globally speaking, in terms of what you should do after you face a refusal.
Perfect. So for temporary, I mean, pass, you told, I mean, it's better to go all the action in parallel. But just this question comes to my mind. I mean, what if the one of the actions got refused again? I mean, all
Oh,
other
it'll happen. It'll happen. Yeah, I called it a tennis match. Yeah, there's times that the tennis game will go back and forth a few times. Had cases where we've gone to court 3 times and won every time in court. We win in court, it goes back to the embassy, they refuse it again. This time we're asking for costs and for damages because it's just obvious that it's like a tennis match. We hit, they hit back, we hit back. It just goes back and forth, and the client doesn't get anywhere, unfortunately, in those cases. But when they're refused, be ready for a second refusal, sometimes a third refusal as well. It's just a question of fighting for your client whose application is credible until they actually get their work permit or permanent residency.
Okay, perfect. Also, I've seen a lot of debate about AI generated reasoning on PFOs. Fortunately, there are a bunch of, I mean, PFOs that kind of seems that AI generated. Although I was in a meeting with IRCC's case managers, and it told us they are doing the final decision without using AI. But I think in some cases we have seen AI generated reasoning. I mean, when it comes to these kind of PFOs, I mean, how professionals needs to deal with this kind of reasoning, which kind of seems nonsense to them.
Mhm. Yeah, Sutton, when we were together in Mississauga around
Yeah,
a month, 2 months
exactly.
ago, yeah, the director of IRCC's um, AI division was actually speaking, and
Exactly.
they mentioned it. They said that we don't use AI to make decisions. We use AI to analyze a file and give the results to the officer for them to make a decision. Now, I mean, there's no secret answer to what you're asking. It's really a question of having a look and seeing what is it that they got in the officer's notes. And I've seen it before as well. I've seen cases where, the ODN, officer discretionary notes, come out like to 3 pages, and you're looking at it, and basically it's everything and anything that was in the file. It's like verbal splash, and it's just there. I've seen it as well. Those cases are usually pretty easy to get settled by with Justice Canada, because they look at it and they say, yeah, it doesn't make sense. It's like the AI malfunctioned and it went on a verbal spillage of fact. So those cases are usually easy to get settled. Ask for a request for reconsideration as well. That would be my That would be my 2 cents on these type of files that seem to have an AI bled decision-making process end up in front of you with things that don't necessarily make a lot of sense.
Oh yeah, you're right, you're right. So before going to the next chapter of a webinar, I wanted to ask another question. Um, I know the trend of refusal has kind of changed with the past, but I've seen in our partners that some kind of actions are kind of underrated. I mean, they are not take some specific actions seriously um, because of that, their applicants kind of face rejections. I mean, what are the, I mean, common underrated actions that our RCICs need to take more serious? I mean, what are the actions that they need to take for helping their applicants?
Sorry, Stan, I'm not sure I followed you. Can you just repeat it one more
Yeah,
time?
kind of. Yeah, I've seen to some RCICs, to some professionals, uh, they are taking different actions, but for some specific actions that are required for current trend of refusals, they need to take some other actions, but they are not treating those actions as serious as required. So, do you have any actions that professionals need to take for their clients to help them to actually avoid refusals for them?
Mhm. I think in terms of answering that question, yes, I think that the practitioners absolutely have to ask themselves when it comes to these business related immigration, how would the business continue if there I know it's difficult because you cannot separate the immigration from the business side on a practical field because
Mm.
the status is going to dictate the development, but you have to try to do the mental exercise of getting past the status blocker of your client and seeing what are the things that perhaps you can help your client do or that they can subcontract to a company whose specialization is that. If you're looking at, if you submitted a startup visa application in 2023, no one is necessarily going to touch your file for another 2, 3, 4 years. So the question that you have to do is you have to find a way and don't shoot the messenger because I mean you can say what I'm saying sounds ridiculous, but you have to find a way to show that the business is still going forward. It comes back to what I said earlier in the presentation. Something's developing. Are clients trying to be recruited? Is the MVP being developed? I mean, MVP, how long can you develop it? Can you spend 6 years developing? So um, these are things that the practitioners should do uh, to try to dissect the business from the immigration. And although it's a business immigration case, to show that, hey, this business has significant benefit, it will continue to have significant benefit, but we need status for our client. And that becomes very, very difficult, practically speaking, especially on the startup visa world. For C11s, it's a bit different, even though processing time sometimes for certain markets can reach 1 or 2 years. It's a long processing time. It's still a lot more manageable than the startup visa one, which is a very problematic situation right now.
You're right. I mean, given the backlog that we have for startup visa, I mean, what's your estimation for this stream? I mean, because
Well,
there are a lot of clients that are waiting for their result.
yeah, I should get out my crystal ball and see what it would be. Yeah, I'm not sure. I hope that IRCC finds a way to process these files in a humane and reasonable and a justifiable manner. But we're gonna have to all wait and see in the case of the startup visa program, unfortunately.
Perfect. Let's jump into the Q&A part of our webinar. I got a lot of questions in the registration forms. I'm gonna read some of them and then we can discuss about the answers. So the first one is, does contacting MPs due to delays make a difference? And what value does contacting an MP on a file have? I mean, once they are waiting for their results, can they talk with an MP? I mean, do follow up with some other authorities or some other stakeholders? Can they do that, or does it have any impact on their applications?
Of course, I mean, MPs will always do a follow-up. What's the value of that follow-up by the MP? I've never seen an MP inquiry be leading to an issuance of like I've never seen a file that was just like sitting there or was refused and then the MP did wonders. I think using the MP is one of the most misunderstood tool. MPs cannot tell officers what to do. They can just ask for specific updates and maybe specific questions about the actual file. And going to an MP and if you go to an MP, you should ask for them to require specific things on your file and not just say, hey, MPs are not immigration practitioners. They're just going to say, what's the status of this file? And no, you should be very specific about what you're asking the MPs to follow up. They don't have any value though. I've never seen the intervention of an MP lead to the reversal of a decision or speeding up an application. It's more, I guess the MPs, they do it because they have to do it, but practical value, I've not seen it much during my career.
Mhm. Definitely. And we got two questions about the startup visa applicants that didn't get their AOR. I mean, one of them is, at what stage should we start engaging IRCC to show ongoing progress and viability of the business? I mean, if they didn't get the AOR, I mean, how they can follow up or how they can engage with IRCC without having the AOR after a year.
Yeah, the IRCC made it even easier now without, they don't even give ARs more than 1 year. I have clients that it's taken 3 years for them to get 2 years to
Yeah,
get the.
we have the same.
Yeah, we have one thing that I've noticed has worked is clients requesting IRCC for a file number, their temporary file number, they end up getting it. I've made the request myself as a practitioner. Seems that IRCC is selectively closing their eyes on these requests from practitioners, but clients themselves, when they requested on their own behalf, they seem to get the file numbers pretty quickly. Now, once you get the file number, then, in theory, you should be showing ongoing progress on your file. And that's something that you should start engaging IRCC immediately. There are also tools that you can use to have IRCC actively process your files. I know that in the past there was GenesisLink did a seminar regarding mandamuses for startup
Exactly.
visa applications. That was at the end of 2025, right?
Yeah, I guess it was end of 2025.
Yeah. So at the beginning of 2026, there was a new federal court decision that came out that was actually for a quota-based program, similar to the SUV, and I think it helps applicants a lot because what the court said is that IRCC has to process the files internally. They have to do the eligibility check, security, background, medical, even if there's a quota. So IRCC cannot use the fact that, hey, there's a quota, and that's why I haven't touched the eligibility of this file, or I haven't completed the security check. So if anybody would like to discuss this later on, send me an email. We can hop on a call, but there are definite steps that you could take for your startup visa applicants now to make sure that the internal processing is completed within a reasonable time frame. So, if you have clients that are sitting in the pipeline since 22, 23, 20, yeah, 24 for sure, but like 22, 23, even 21, some of them, if you do get the GCMS notes, you realize that nothing's happened on the file, and the court, we can take action against those works for sure.
Perfect. I got another question, which is, if a client has a prior refusal on record, how much does it hurt to the next application, and how do you naturalize it? I mean, I've seen a lot of clients that already has refusal, but I don't know how is it a good idea to, I mean, apply for another program or not, or how professional needs to, I mean, treat them.
I mean, when you get a refusal, it's always you have to look at the refusal, see what the where the mistake was. Was the mistake in the file? Was the mistake with the officer? If the mistake was with the officer, then we go towards the other areas that we talked about. If the mistake was yours or the files, then it's a question of resubmitting if possible under the same program while fixing the issues. If not possible and you're submitting on their new program, then you have to explain why you're submitting under this new program. You have to be very, or you have to have a narrative and a credible story of, yes, I was trying to apply for this program before, but now I'm trying to apply for this program because I was refused. And you have to be careful not to look at, you have to be careful to sound genuine and that you're not just immigration shopping or door shopping to see what program can get you into the country.
Okay, perfect. And another question from Chatbox from Sanjay. Considering the projected timeline of 10-year processing for CV clients, if an essential applicant wants to withdraw and try another program or got approved for another program for PR, what are the legal options in these cases? I mean, I've seen there are a lot of applicants that are waiting in Star Visa and they want to get their PR, so they are trying to apply for other programs. I mean, is it a right path or
Yeah,
I
I mean, look, you can't blame the clients because they obviously want their permanent residency. If they're essential and they do that, well, I think we're all familiar with the rules. That means the death of the group. So, one essential that drops out, changes programs, then the group is done for. Practically speaking, I've had clients make new applications for PR and they're just waiting to see that which application is going to get processed more quickly. In PR, however, if in practical sense, when you submit a second application and you have a first one pending, IRCC is supposed to ask you which one you'd like to withdraw. In theory, they're supposed to process the old one, but they'll ask you, do you want to withdraw the old one? And unfortunately, that's going to turn into a big headache if an essential applicant drops out.
you're right. So it's another question here. What's one thing every RCIC should stop doing on business-wise in 2026? Um,
Over promising the moon on every application. Uh, it's we're in a difficult situation where we have to prove significant benefit to the Canadian economy while submitting a business plan that remains reasonable, rational. Most of our clients, they're not ultra sophisticated individuals having operated or having started businesses in multiple countries. Sometimes they have, sometimes they have, but most of them
right.
have not. So you have to tailor your business plan and what you're promising. Don't promise the moon. You're not going to see a venture capitalist here. Stay as grounded as possible. It's better to. I'm going to compare the turtle and the rabbit. So it's much better to be the turtle than the rabbit because the number of cases where I've gone to court and you look at the business plan that's promised and yeah, if you're going in front of sharks then or you want to go in front of venture capitalists, yeah, you're going to exaggerate and say after year two, I'm going to have my corporation is going to be earning 35 million in revenue. Okay, take it easy. How many companies in Canada generate that kind of revenue right now as we speak? So dial it down, make it reasonable. Don't exaggerate, don't make promises that don't make sense. And the business plan and idea has to be suited to your client's background. And that's also very important. If you had a guy who was a running, I don't know, for example, a computer, um, a, a business teaching computers in a rural area, um, in their country, let's say like for example, let's say like in India, and the kind of like a village place, and you're bringing him here, downtown Toronto on Yonge Street, and he's going to build the most high-tech computer education center in Toronto, you know, take it easy. Uh, go with what the track record is of your client and stick with that as much as possible. Before jumping or flying, you have to walk. So that's what I would say is the number one thing. Stay very sober and reasonable in what you're presenting to the immigration officer. Don't promise 20 jobs. There's no reason for that.
Perfect, thank you. And also another question from Chatbox, which is about C11 extension. What's the minimum action we have to take for the C11 work permit to be extended for the second time?
That's a very good question. When you come to reapply for or when you come to extend the work permit, basically you promise something on the way in. They provided you a work permit, or I mean, yeah, to be for work permit. You said, I'm going to come and do ABC. They gave you the work permit. You had a business plan that promised ABC in year one. The person's here, they had 1 year or 2 years, I don't know how long they had their work permit. Usually they get it for 1 year. Did the objectives that were in the business plan get met or not? If they didn't, if they got met, by all means, Mazel Tov, you can get an extension. If they did not all materialize, then you have to explain why they didn't materialize and what is the action plan to make sure that you stick as much as possible to the business plan that you submitted. So it's without the actual business plan and the actual file, I couldn't tell you what is the minimum action to take. It really starts with what was promised to IRCC at the outset.
Yeah, thank you. And another question that I got a lot was about the nomination for PMP programs. I've seen some clients that did all the things. They got the ITA, they ran the business, they showed all the progress, but they didn't get the nomination. Do they have any actions to take for getting the nomination for their PMP applications?
What was the reasoning for them not getting their nomination? Do you have an example in mind?
So it's a kind of case-based, but yeah, but I mean, they did all the things, but they couldn't get the nomination. Was the
Well,
was
because usually for PNP programs, you have a performance agreement that if you
Yeah,
meet performance agreement and you give your report, you should get the nomination. Now, if you didn't get the nomination, it's because what you did in terms of carrying out your business plan and what you signed in terms of your performance agreement don't make sense, or yeah, basically you violated your performance agreement. That's
you're
what
right.
those are the reasons why you don't usually get nomination. And we have to look at the officer's reasoning to say, hey, why was this person not provided nomination?
Okay, yeah, I think it's kind of case-based. Yeah, you're right.
Absolutely.
And another question about the MTA star visa applicants that they are actually paused. I mean, how do they have any actions for, I mean, follow-up for their LOS or their procedure?
As far as I know, IRCC is still looking into the matter. There are different lobbying groups, and I think there was a few lawyers that started looking at the possibility of filing some kind of procedure with the court when the news first hit. I'm not sure where they got to that right now, whether that's still going forward or not, but I've not received any updates in terms of IRCC continue to process those files. They're still administratively not being processed.
Perfect. So I think now I've I mean, all of questions have been answered. So Iman, do you have any last note for our audience? Do you have any points to add?
I would say that immigration is cyclical. I think we're all have realized that we are at the bottom of the cycle at the present moment. I do foresee and I do hope that business immigration paths become more streamlined quickly by IRCC because it's something that we absolutely need in Canada. There is no way we can close our door to business immigration It's just we're all crossing our fingers that within the next year or 2 years, there will be a system where our clients can come in, and we don't have to necessarily send them to, I don't know, Europe, another country, just because Canada has no way for business people to come in.
You're right. Perfect. Thank you. So I'm going to send the contact of Iman, our team, to all the audience, and also the recording and all the things that we discussed to have the notes as well. And just that you can ask your questions through our emails. I mean, after this meeting, we're going to send a survey to you. If you have any points, any questions, you can add to that survey, and we're going to get back to you shortly after receiving all the questions. And thank you. Thanks a lot, Iman. Thank you. It was really helpful. It was really valuable to me, at least, because we were dealing with a lot of clients. And I know these days people are dealing with these kind of challenges. And thanks. Thanks a lot.
Thank,
Thank you.
thank
Thank
you
you.
for
Thank you.
thank you for having me. It was a pleasure, and thank you for everyone in your attendance.
Perfect. Thank you. Thanks a lot. And have a good one.
Same thing to you guys. Enjoy the rest of your week.
Yeah.
Bye bye.
Bye. Take care.